Imagine signing a deal, then someone says, "Oh yeah, we also agreed to something totally different, but it's not in writing." Sounds shady, right? That's why the Parol Evidence Rule exists, to keep contracts clean and trustworthy. But here's the twist. Courts do allow secret side info in, if it fits one of 5 powerful exceptions. Welcome to 99 Rights, online, where we turn courtroom chaos into clarity, and your crash course in rights, rulings, and real-world justice. We simplify the law without dumbing it down, because informed citizens make powerful communities. Because knowing your rights isn't optional, it's survival. So let's talk about the 5 core exceptions to the Parol Evidence Rule. Also, these aren't loopholes, they're truth detectors. Let's break down how judges use these exceptions to sniff out fraud, fix mistakes, and make sure contracts reflect what people actually agreed to. So what is the Parol Evidence Rule? The Parol Evidence Rule bars extrinsic evidence from altering a written contract. But, as there always is in law, 5 key exceptions allow it in. These exceptions help courts uncover the truth about what the parties actually agreed to. The Parol Evidence Rule says that when parties sign a written contract intended as the final agreement, prior or contemporaneous oral or written statements cannot be used to contradict it. This protects the integrity of written contracts and prevents one party from claiming secret side deals. But courts recognize that reality is messy, so they've carved out exceptions where outside evidence can come in. Okay, imagine you and your friend make a deal and write it down. Like, "I'll trade you my toy car for your action figure." You both sign it. That paper is your official agreement.
Now, later on, your friend says, "Wait, I also said you had to give me a cookie too." But you're like, "That's not in the paper we signed."
The Parol Evidence Rule is like the grown-up version of that. It says, if you wrote down your deal and signed it, you can't come back later and say there were secret extra rules that aren't in the paper. But life isn't always that simple. Sometimes people agree that the deal only counts if something else happens first. Like, "We'll trade toys only if my mum says it's okay." So the court says, "All right, we'll listen to those extra details if they help us understand what really happened." That's called an exception. It is a special rule that lets the court hear more than just what's on the paper. So behold, the Big 5. The legal avengers of contracts. 5 exceptions law students memorize, lawyers weaponize, and judges dramatize. They show up in textbooks, trials, and yes, your TikTok feed if you're lucky. Number 1. Is the writing the whole deal? This is called integration. It means sometimes people write part of a deal down, but not all of it. This rule lets the court ask, was this paper supposed to be the whole agreement, or just part of it? What it does, it helps judges figure out if they should look at other stuff, like earlier talks or side notes, to understand the full deal. They are allowed to look at all the evidence to determine integration. Number 2. New promises made after the paper was signed. These are called subsequent agreements, which means, after signing a contract, people might make new promises or changes. This rule says, if you made a new deal after signing, we can talk about it. What it does, it lets courts include updates or add-ons that happened later, even if they weren't written down. Number 3. What does this even mean? That is interpretation. Which means, sometimes words in a contract are confusing. Like, does delivery mean by truck or by email? Also think about dollars could mean USD, United States currency, or CAD, Canadian currency. Evidence shows what parties meant. What it does, it lets courts use outside info to figure out what the words really meant to both sides. It clarifies vague or unclear terms. Number 4. Was there a secret condition first? We call this condition precedent, which means maybe the deal only counts if something happens first, like getting approval or passing a test. What it does, it lets courts hear about those before the deal conditions to decide if the contract ever really started. It shows the agreement wasn't binding until a condition occurred. Remember, Pim v. Campbell. the case where the contract was only valid if engineers approved it. Number 5. Was someone tricked or forced? We call this avoidance, which includes fraud, duress, and mistakes. Which means, if someone was lied to, pressured, or made a mistake when signing, this rule says, we need to hear about that. What it does, it helps courts protect people from unfair contracts caused by bad behavior or honest errors. This reveals misconduct or errors that render the agreement invalid. This may also indicate coercion or a typo in the price. So, why do these exceptions matter? Imagine someone tricking another person into signing something confusing. These exceptions help protect people from being fooled or forced into something they didn't really agree to. Also, when people invent cool stuff or start new businesses, they often make deals that depend on other things happening first. These exceptions help make sure those deals are fair and don't hurt the little guy, like inventors or small business owners. It's like saying, yes, we have rules, but we also have ways to make sure the rules don't hurt people who are trying to do the right thing. This is contrasted with UCC Section 2-202, which allows trade usage and course of performance to supplement contracts in commercial settings. Basically, if people usually do things a certain way or have done it that way before, we can use that to help understand their deal. Also, the Restatement, Second of Contracts, codifies these exceptions and guides courts on integration and interpretation. Basically, that says, here are the rules and exceptions to help judges decide what the deal really means. If this breakdown made the law feel a little less intimidating and a lot more powerful, don't scroll away just yet. Like, subscribe, and share to keep your rights sharp and your feed spicy. Because justice isn't just for lawyers, it's for everyone. This was 99 Rights Online, where law gets loud, clear, and viral. Subscribe for justice that hits different.